Hi guys, welcome back to my channel. This is Batok with Ola. My name is Mujela Olua. Today I want to quickly address a few questions, and I want to talk about court processes, the way that proceedings progress in court. That's because two different people have asked me on the channel what a lawyer is supposed to do, or what happens when a matter is for mention, for hearing, and so on and so forth. So today I want to talk about those things. So ordinarily in the Nigerian court, when a matter is in court and it's assigned to a court, the first time that it comes before the court, it comes up for mention. So when you check the court list for that day, you would see matters that are for mention, for hearing, for further hearing, for hearing of application, and so on and so forth, for judgments, for adoption of written address, as the case may be. Those divisions, they outline what each matter is up for per day in court. So let's start from the first, for mention. So if the matter is for mention, it simply means that on that day, both parties will come, the matter will be called, and they will just announce their appearance. Usually matters that are for mention do not go on that day that it is listed for mention. It means that when your matter is called, you say, "My lord," you announce your appearance for the claimant, you announce your appearance for the respondent, and then the parties will stand up if they are in court. The court will note that they are present. Then just for the court, and if it's a criminal case, you announce your appearance. The court wants to ascertain that the defendant is in custody and is present, or if he's on bail, is here and is legally represented. So nothing really goes on when a matter is for mention. But it's tricky because in most courts in Nigeria now, judges tend to say that matters listed for mention can still go on if the parties are ready. That is, if you bring your witness to court on that day and you're ready to open trial, they can still go on to hearing. But if not, a matter that is listed for mention is just meant to be called so that it will be registered that this matter is before this court, the parties are present and ready, and they are legally represented, and the parties have witnesses, and they are ready at the next adjourned date to open trial. So that's essentially what a matter that's listed for mention is. It is to be mentioned in court so that it can be judicially noticed, and so that the court can, have notice of the fact that the parties are ready to go on to hearing. Usually the next thing is for hearing. That's if it's a criminal matter. But if it's a civil matter, it could be listed next for PTC. That's Pretrial Conference. When it's listed for Pretrial Conference, both parties will come, and they must have filed their pleadings at this point. So it's at that stage that the court will ask claimants, how many witnesses are you calling in this matter? Defendants, how many witnesses are you calling in this matter? Have you filed any application? Is there any contentious application? Are you tendering any documents in this matter? And so on and so forth. Pretrial conference is just the point where a matter will be called up in court, and both parties will just explain what they are going to do in the matter and the things that are involved. If they have witnesses, if they are tendering any document, if they are calling any number of witnesses, if they are doing any special thing, if there are any contentions, if they have joined issues on any point, and if they are raising a preliminary objection, all sorts of things that are going on in the matter, they will be settled at the pretrial conference stage. So that's what happens on the day that a matter is listed for pretrial conference. So that's only for civil matters. In criminal matters, after for mention, it's for hearing. Now the next stage is for hearing of pending applications. If a party has filed a preliminary objection, for instance, or if a party has filed any application, for instance, in a criminal matter, a party might have filed an application for bail. So the matter will not go to hearing, which it should ordinarily be the next stage. It will be listed for hearing of pending applications. And that's when bail applications are heard, preliminary objections are heard before the court, application for injunctions, for stay of this or that, are heard by the court before the matter proceeds. So on the day when a matter is listed for hearing of pending application, or hearing of application stricto sensus, that day a party would come and move an application that they have earlier filed in that matter, and the court will hear them. If the other party has a response, they would respond to it, and the court will make its ruling or adjourn for ruling. The next thing is a matter could be listed for hearing. When a matter is listed for hearing, it means that the court is ready to hear it and the parties are ready to be heard by the court. So on a day when the matter is listed for hearing, what happens is that the party that is appropriate, either the claimant or the prosecution, opens their case by calling their witnesses, their first witnesses. CW1, claimant witness 1, or PW1, prosecution witness 1. They call their witness, who is examined by them and then cross-examined by the other party, and then re-examined if necessary by them. After which, they call the next witness, call the next witness, call the next witness. So they can take as many witnesses as they may on that day. And if they cannot conclude their case, and if the defense cannot also open their own defense and conclude it on that day, the matter will be listed for further hearing. So on a day when the matter is listed for further hearing, giving of evidence continues in that matter. Trial continues. So when both parties have closed their cases, that is when they have called all witnesses that they intend to call, and those witnesses have been cross-examined and re-examined, and they have told the court that they've closed their case, the matter is then listed for adoption of written address. After the closure of each person's case in a matter, it is listed for adoption of written address. So both parties will take a date to file and exchange written address. In criminal cases, for instance, parties have 21 days each, to file their written address. So that's about 42 days. So the court will adjourn, counting 42 days and over, for adoption of written address. So the next date, the matter will be listed for adoption of written address. That is when both parties will come and adopt before the court the written address that they have earlier filed before the court. I've done a video on adoption of written address already. I'll leave a link to it in the description box and link it up as well. So after the matter is listed for adoption of written address and parties have adopted, the matter is then listed for judgment. That's the last stage, listed for judgment. Now note that where it's an application, the matter will be listed for ruling. But where it's the final judgment, the final decision of the court in that matter, and parties have closed their cases and adopted their written address, the matter will be listed for judgment. So that's how cases are listed. So on that day, parties will come and hear the judgment of the court, and that is the end of the matter. So from being listed for mention to being listed for judgment, mind you, there are several pauses and junctions along the way. It could be listed for hearing of application, listed for ruling, listed for pretrial conference, listed for further hearing, and so on and so forth. But that's how matters are listed on the court list, and that's what happens at each stage of court proceedings. Also, in a criminal trial, a matter might be listed for arraignment. It's essentially listed for hearing, because arraignment is the beginning of hearing. I've done a video on arraignment. I'll leave the link to it in the description box and link it up as well. So arraignment is the opening of a criminal matter. So if it's listed for hearing, it could also be for arraignment. But if it's listed for arraignment, it could be strictly sentenced for arraignment, and the court can decide that after arraignment you should proceed with your matter. So a lawyer should always be prepared, because if a matter is listed for a particular thing, especially if there's no ruling or decision of court to be made after that thing has been done in court that day, the court may decide to ask the parties to continue with their matter, that is, move to the next stage, even if you have completed what it was listed for today. So parties must always be prepared. I hope that I've answered the questions of those two people. I will always see you in my very next video. Toodles.